thank you for inviting me to speak today. And let me just say thank you as well to Kamini and Dr. Catherine and the rest of the speakers, because it was really invaluable to hear the insight from people on the ground and who work with migrants and families and children, whether documented and undocumented. It was really enlightening for me, who only thinks about these things from a legal perspective most of the time. And it was really great as well to hear from the ministry as well and their take on the issues. Just a short introduction. I am Aneera Chowdhury. I run a small legal practice in Bangsa South in KL. And part of my portfolio is advising on child protection and labor law issues. And today, I won't take up too much of your time. Today, my main role is to provide a brief overview of how to think about child protection issues in terms of legality and risk to those involved in the oil palm industry. So I'm just supposed to give a very brief overview on legal considerations and what corporate, how to look at it from a corporate perspective. Now, the best way to think about this is to start by considering the inherent rights that no one can take away from a child and then work from there. I won't go into what these specific rights are because Kamini has done an amazing job at it. Safe to say that these rights are broad and they are across the board. The children have a right to be basically protected, nurtured, and be free from all forms of violence, abuse, neglect, maltreatment, or exploitation of any kind. Once we understand what these rights are, it becomes easier to extrapolate what corresponding responsibilities of others are in relation to those rights. Those responsibilities are basically to protect the health, safety, and also morals of children. And the practical aspect of this is that there are then clear duties and obligations to not interfere, and at times to actively protect these bundle of rights that children have. And anything that fails to protect or that interferes with this bundle of rights then becomes risk, whether legal or corporate or commercial. For example, today is a really good example. Top Glove, I think, is not having a good day today because one of their shipments has just been blocked due to allegations of forced labor. Therefore, it is easy to see that these issues to do with migrants, how one treats one's labor and one's workforce has extremely wide and sometimes criminal consequences. Yeah. Now, when we talk about legal risks, we also talk about direct and indirect legal risks. For example, whilst a plantation owner may not directly employ a child, there may be employees on the plantation who bring their children to work, whether it's just to watch over them or to care for them, or whether they are living on the plantation, or even sometimes to assist them in their work. Now, for wages, for situations where wages of the oil palm workers are dependent on the fruits harvested or based on the yields that they provide, it is not uncommon to find children in the plantations helping out in the activities that would then add to the yields, right? So whilst not directly employing children, such a scenario will still engage different rights and obligations for employers and those in the industry. Therefore, the industry has to self-regulate itself, not least because it is becoming a hot issue nowadays. And it is also because, as Kamini put it, all the legislation does is to provide bare minimum standards that you should implement, but it doesn't mean that those should be the standards to be implemented. The better the standards are, the better your labor workforce is treated, the better your yields for the owners of the plantations. And also when it comes to protecting or thinking about child protection, it becomes also a moral and social responsibility. And while you may think that moral and social responsibilities have nothing to do with legal responsibilities, they indirectly do, in the sense that most of our laws that are drafted take into account moral and social considerations, and such laws will always be more protective of the rights of a child as against the rights of others. Yeah. There has been international consensus on what the rights of children are and what they need and what needs protecting. There is the CRC that was ratified in 1995. A direct consequence of the CRC was the fact that we now have a Child Act. And we have also legislation on the sexual exploitation of children. Now, Malaysia, being a signatory of an international convention, does not automatically make the provisions of that convention law. In Malaysia, we have a two-tiered system where we need local laws enacted that would codify the international obligations before it becomes binding. And when we did ratify the CRC, we had reservations to it. I think there were about 4 or 5 reservations. Reservations meaning we disagreed to certain of its provisions. And one of them was the fact that we disagreed to Article 37 on torture and deprivation of liberty, and we disagreed to Article 7 on name and nationality. And that really means that out of all the unprotected children in Malaysia, the ones who are not documented are right at the bottom of the ladder, right? There are also the International Labour Organization Conventions on child and forced labor and minimum ages. And on top of that, we can find guidance from the UN on their guiding principles on business and human rights and their child safeguarding toolkit for business. There are plenty of reports, the ministry's report, Wilmar report. There are plenty of write-ups on what international standards are on child rights. There is a lot of material out there that can help inform us as to what the rights are and how they are to be protected. And these should be used as a starting point as well. And Malaysia is committed to its Sustainable Development Goal, which basically target 8.7 says, we are meant to take immediate and effective measures to eradicate forced labor, end modern slavery and human trafficking, and secure the prohibition and elimination of the worst forms of child labor, and by 2025, end child labor in all its forms. Therefore, the laws that deal with child protection are only going to get stronger, not weaker, as we move along. It is the practical implementation of these standards that is the more complicated, bearing in mind how huge plantations are, how huge some corporations are as well, and also bearing in mind how many laws are triggered by the employment of workers, both migrant, foreign workers, and local workers. And to make matters a little bit more complicated, there is a somewhat differing legal framework between East and West Malaysia, which the next 2 speakers will be talking more about. So the main concern is to ensure that you as a plantation owner, or you as being part of the industry, is to make sure that you are complying with all your legal obligations and implementing the best possible practice that you can within your industry. The way that I approach this problem is by asking questions to my clients, which is, are you aware and have you codified in some way the applicable laws or the laws that apply to you within your locality? Because you have to know what the laws are for you to be able to work within them and for you to draft your own internal policies and best practices that will be applied in the company. So in Malaysia, we have various labor ordinances. We have the Employment Act, which is for West Malaysia. We have the Sarawak Labor Ordinance for Sarawak and the Labor Ordinance also for Sabah. For West Malaysia, we also have the Children and Young Persons Employment Act 1966. And I think Mr. Nicholas Wong will also be talking about the corresponding East Malaysian legislation. It is written in this act that the employment of a child or young person should not be dangerous to life, limb, health, safety, or morals. Yeah. And within this act, there are 2 minimum age requirements, which we've already talked about. That minimum age requirement is different when we define a child vis-a-vis the Child Act, and it's also different when we define a young person vis-a-vis the Factory and Machineries Act. Other types of laws that you will need to know about would be the Anti-Trafficking in Persons Act, the Factories and Machineries Act, like I've said, the Occupational Safety and Health Act, 1994, where in this act you can find general duties of health and safety that apply to employees that apply not just to employees, but also to the employer's duties as occupier of the premises or the land. And then we have various legislation and regulations on minimum standard of housing as well, where children come under the definition of dependents. And aside from statutory duties, which would apply, we also have what your contractual obligations will be vis-a-vis your employees, your suppliers, your third parties, your independent contractors, your service agencies, and the other people that you generally tend to do business with. And you also have, on top of that, even though you may not have a contract with this person or this company, you may have duties of care nonetheless that go beyond what contract is. Now, knowing about the concept of duty of care is important because it applies whether or not there's a written agreement or not. It applies due to the special relationship that you may have with the person. For example, an employer has a duty of care to ensure the health and safety of the employee. An employer who is also an occupier of premises or land has duties of care vis-a-vis their occupier's liability and obligations. On top of duty of care, which is not written really in any law, we also have the concept of vicarious liability, in which the employer can be made responsible for unlawful actions of a third party. Oftentimes, the wrongful acts done by employees can also reach the employers in the sense that the employers may be found vicariously liable as well. So that is the second question to ask on top of applicable legislation. What other duties would you have that is not written anywhere but apply to you nonetheless? The third question would be, once you know all of these things, do you have SOPs in place that specifically cover how you carry out these duties and how you apply the legislation? A very good example would be to look into your hiring practices and to see whether your SOPs or the way you run your company has comprehensive interviews, whether you do your age checks. How do you verify your age? Do you just take their word for it? Do you ask for documentation? Do you run background checks on your employees? There is now a sexual offenders registry. Do you run background checks on that, which you should do, particularly if you do have children on your premises? Do you conduct assessments as to what type of work is required? How do you define it? Is it light? Is it heavy? Is it hazardous? Do you know who at all times is doing the work? Are you able to say 100% that your supply chain is completely free of child or forced labor? If you're not able to say that, do you conduct regular assessments to check that? Do you require, when you hire people, for them to disclose whether they have a criminal background or anything that may prohibit them from working with you, especially if you have children in the plantation? You should then also check your SOPs to say that, there should be SOPs in place that cater for who the person in charge is within the company, under whose responsibility it comes. Do you have a committee, especially for child protection? Who has mandate to deal with the problems? Is there a complaints mechanism? And does HR know how to deal with, and have they been trained in dealing with problems to do with child protection? Now, strictly speaking, SOPs like these are not strictly necessary, and this is actually the point that I want to end with today, is to say that whilst not legally necessary to have, these in-depth SOPs, if you look at it overall from the perspective of risk, having such clear and specific policies in place will ultimately result in risk, legal and corporate risk, being reduced anyway, and reduce the risk of something going horribly wrong down the road. The last thing I want to say is that there also are duties that apply to you in terms of reporting if you are aware of a case of a sexual exploitation of a child or a crime being committed. Vis-a-vis the Sexual Offences Against Children Act and the Penal Code, there are also duties to report. I'm not going to have much time to go into anything else, but in terms of the West Malaysian law, Ms. Sara Lau will be able to provide excellent insight into maternity and child protections, and Mr. Nicholas Wong will provide his expertise on East Malaysian laws. Thank you so much for your time, and I will now pass the space on to Sarah. Thank you.
Hi, everybody. Let me just get this in order. Okay. Hi, everybody. My name is Sarah. I am an employment and labor lawyer working in West Malaysia in Kuala Lumpur, one of the largest law firms. And I'm very privileged. I feel very privileged to be able to share with you today. And I feel even luckier to have logged in a little bit earlier and to have heard from Kamini and from Catherine, and also from what Aneera has just given a broad overview of. Now, I see, sorry, I see the topics that I will speak today as an extension of the issues that Kamini has brought up in the earlier session. So I think that's a good combination. Kamini was talking about how we had ratified certain international conventions, and we needed to see whether that had trickled down into our legislation to be able to provide the adequate protection to children and to laborers as a whole. So let's take a look let's take a look at our labor legislation and our children's labor legislation and see whether we measure up to international standards. Just a qualification before I begin. The laws in West Malaysia and East Malaysia are not always the same. Now, particularly where the employment of children and where employment in general is concerned, there are different laws which apply to West Malaysia and to East Malaysia. So Nicholas, my fellow panelist, will be speaking about East Malaysia, whereas I'll take you through West Malaysia. Now, I am aware that the concerns that we are speaking today largely impact issues in East Malaysia, so I will be mindful to give priority to my fellow panelist Nicholas, so that he'll be able to address these issues in more detail. Okay, so without further ado, let's begin. Okay, the first thing to note is that there are a couple of legislations in Malaysia which pertain to minimum terms and conditions of employment. Actually, there are many type of legislations in Malaysia. One of them is even the minimum wage order. However, many of these legislations are geography specific. So like I was talking about the minimum wage order, even the minimum wages in Peninsular Malaysia is different than East Malaysia. Even within Peninsular Malaysia, it's different depending on the locality and district that you live in. So some labour legislations may be enforced in Peninsular Malaysia, but the same will not be enforced in Sabah and Sarawak. Now, one such legislation is the Employment Act 1955, which is applicable to workers in Peninsular Malaysia only. It is our fundamental legislation that protects only a certain category of workers. And these category of workers are those what we call who engage in lower level labor. They earn 2,000 ringgit or less, or regardless of how much they earn, they are involved in manual labor. Now, working in a palm oil industry, which is part of an agricultural undertaking, would fall within the group of workers which are protected by the Employment Act 1955. Now that we have established that a certain group of workers or employees fall within the Employment Act 1955, it is important to take note of the minimum terms and conditions which is governed by the Employment Act 1955. These minimum requirements in relation to terms and conditions of employment include in relation to work hours, rest days, work on a rest day, shift work, overtime payments, protection from deduction of wages, public holidays, annual leave, sick leave and hospitalization leave, payment of termination benefits, time for payment of wages, notice of termination of contracts, and of course there is also a category which applies to the employment of female employees. The one thing that's important to remember is that any term or condition in an employment contract entered into with these category of employees, including those who work on the palm oil plantation, which is less favorable than what is prescribed under the Employment Act 1955, will be void. So essentially what this means is that these provisions on work hours, rest days, all those which I've stated earlier, they must be in compliance with the law, and they must be in compliance with the minimum requirements of law. As Kamini had stated earlier, the Employment Act provides the minimum standard, and we have to be a self-regulating industry. Although this is a minimum standard, that's not the required standard to adhere to. What I mean to say is that we can generate our own policies and our own terms of conditions of employment, which are more favorable than these minimum terms and conditions under law. And this will actually help alleviate the social problem and the social cycle that involves the employment of children. Non-compliance to the minimum standards, however, will invite fines and penalties. Depending on what the offense is, you are looking at least a penalty of 10,000 ringgit. And on top of that, you will also be required to reimburse the employee for what you had deprived them of. So for example, if you had not paid them for overtime payments, you must reimburse. Now, another thing that's important to remember is that there is no discrimination of foreign workers where the Employment Act is concerned. So what this means is that minimum terms and conditions of employment is as applicable to non-Malaysian workers as it is to Malaysian workers. This is also the case where there's a collective agreement in force. If there's a collective agreement in force, it must also apply to those foreign workers who fall within the scope of the collective agreement. So in that sense, I think it's important to remember that no distinction should be made between the type of workers that are engaged in the palm oil industry. They should be treated fairly. They should be treated equally. They should not be discriminated simply because they are not Malaysian. So for corporations, I think the first basic thing to do is look through your employment contracts, your collective agreements, your employment handbooks and policies. Do a general and brief assessment on whether these provisions, which I've spoke about earlier, are in accordance with the statute, or are you offering something better? Can you afford to offer something better? Okay, so now I want to briefly move on to the employment of women. Women enjoy some additional minimum terms and conditions of employment under the Employment Act. For example, they are entitled to a maternity benefit. Generally, a female employee is entitled to 60 days of maternity benefit with some preconditions, for example, in relation to the number of children, how long they've been employed. But generally, they have 60 days. So ensure that your female employees on site are enjoying that 60 days of rest, 60 days of leave, yet getting fully paid. Additionally, under the Employment Act 1955, there is a general prohibition on requiring women to perform night work in an industrial or agricultural undertaking. So as we stated earlier, the palm oil industry is an agricultural undertaking, so this prohibition of night work applies. Between the hours of 10 p.m. and 5 a.m., no female employee should be required to work. Okay, so that's another thing to take into consideration. Are you requiring your female employees to work at night? And if so, please take note that that is a non-compliance with the Employment Act, which will invite penalty or fines. A lot of the conversation today had revolved around employment of children in palm oil estates and child labor. I think the first thing that springs to mind when you talk about the employment of children is child labor. As Kamini had stated earlier, they are not the same concept. Child labor is not the same as employment of children. Child labor may be prohibited, but the employment of children is regulated in Malaysia. In Peninsular Malaysia specifically, there is a statute governing the employment of children and young persons, and it is called the Children and Young Persons Employment Act 1966. So this applies to the whole of Peninsular Malaysia and to the Federal Territories, but it does not apply to Sabah and Sarawak, where I believe the problem is more prevalent. Okay, having said that, I think it's still beneficial to go through the Children and Young Persons Employment Act, and we can take a look at its provisions to see whether the broader issues which Kamini had described earlier is now encapsulated within our own local legislation. As Aneera had said, ratification of international conventions, including the rights of the child, that is not going to have much practical effect unless those provisions have first been incorporated into local legislation. So under the Children and Young Persons Employment Act 1966, let's look at the definition of a child or young person. A child means a person under the age of 15 years, and a young person means a person who has attained the age of 15 years and under the age of 18. So child is under the age of 15, young person means 15 to 18, okay? Section 1A of the Act says that no child or young person shall be or be required or permitted to be engaged in any hazardous work or any employment other than specific in this section. What this means is, besides the work that's allowed under the statute, children or young persons may not be employed. Hazardous work is defined in the fourth schedule and does not rule out agricultural sectors. Similarly, under the newly added fifth schedule, which lists the type of employment that children are not allowed to engage in, agricultural undertaking is not included. Okay, does this automatically mean that children may be employed in palm oil estates? It does not necessarily mean so, because under the Act, a child may only be engaged in specific categories of work. Firstly, employment involving light work suitable to his capacity in any undertaking carried on by his family. So this is like a family-run business. B, employment in any public entertainment in accordance with the terms and conditions of a license granted in that behalf under this Act. C, employment requiring a child to perform work approved or sponsored by the federal government or government of any state and carried on in any school, training institution, or training vessel. And D, employment as an apprentice under a written apprentice contract approved by the Director General with whom a copy of such contract has been filed. Additionally, the age of admission to light work as specified in paragraph A, as I stated earlier, shall be no less than 13 years. Essentially, what this means is that a child below 13 should not actually be engaged in any type of labor. A child above the age of 13, a child 13 years and above may be engaged in light work. Okay, light work under the Act means work that is not considered to be harmful to his health, mental or physical capacity, or to prejudice his attendance at school, that includes any place which teaches any religion, his participation in vocational orientation or training programs approved by the competent authority, or his capacity to benefit from the instruction received. So a child which engages in light work, you must be careful to ensure that the work is not harmful to his health, mental or physical capacity and does not prejudice his ability to attend school. So now the thing to consider with palm oil estates is the type of work that the children is doing light work. There has been discussion just now about how some children follow their parents to work. What are they doing? Are they doing the part of work that's light, or are they doing work which should be done by an adult or at least a young person? I think that companies need to take a proactive view on this and not just turn a blind eye in saying, okay, look, a child is following the parents to work, I'm not requiring the child to work. But we need to be proactive and practical about it, because these are things that happen. They have no childcare at home. They have no after school activities to do. So we need to be able to provide them with that kind of protection, simply because due to the circumstances that they live or are born in, they cannot access that type of privilege. Okay, now there are also applicable conditions under the Act which must be adhered to. For example, Section 4 of the Act says that no child or young person engaged in any employment shall, in a period of 7 consecutive days, be required or permitted to work for more than 6 days. So easily summarized, this means that in a week of 7 days, they work 6 days. Okay, there are also restrictions on the numbers of hours of work. No child engaged in employment shall be required or permitted to work between the hours of 8 o'clock in the evening, 8 p.m. and 7 a.m. Okay. However, there is an exception for children in an agricultural undertaking. They should also not be required or permitted to work for more than 3 consecutive hours without a period of rest of at least 30 minutes, to work for more than 6 hours in a day, or if the child's attending school for a period which together with the time he spent attending school exceeds 7 hours, or to commence work on any day without having had a period of not less than 14 consecutive hours free from work. Whereas for young persons, no young person engaged in any employment shall be required or permitted to work between the hours of 8 o'clock and 6 o'clock in the morning. Of course, exceptions apply in an agricultural undertaking, to work for more than 4 consecutive hours without a period of rest of at least 30 minutes, to work for more than 7 hours in one day, or if the young person is attending school for a period which together with the time he spends attending school exceeds 8 hours, provided that if the young person is an apprentice, the period of work in any one day shall not exceed 8 hours, or to commence work on any day without having had a period of less than 12 consecutive hours free from work. On top of all that, on top of the hours of work which they are required to work and the days of work, it is also important to remember that the provisions of the Employment Act apply to a child or young person that's employed in the same way it applies to an adult. So this means that they still have to be given their wages on time, they still have to be given overtime, they still enjoy the protection from deduction of wages, they still enjoy public holidays or annual leave, they should be given sick leave, hospitalization leave, they are entitled to payment of termination benefits if for any reason their employment is terminated. Okay, so a child and young person, if anything, have an added measure of protection to what the Employment Act already prescribes. Any person which contravenes the provision of the Child and Young Persons Employment Act shall be guilty of an offence and shall be liable on conviction to an imprisonment for a term not exceeding 2 years, or to a fine not exceeding 50,000 ringgit, or to both. And in the case of a second or subsequent offence, there are stricter penalties. So there could be a imprisonment for a term not exceeding 5 years, or a fine not exceeding 100,000 ringgit, or to both. One thing that is also crucial to note is that if the person committing the offence is a body corporate, and the person who is a director, manager may be found liable for the penalty. Okay, so in gist, those are the laws relating to the employment of children and young persons, which relate to work in an agricultural undertaking. And without further ado, I would like to pass it on to Nicholas to talk about the considerations from the East Malaysian perspective.
Hi. Hi, everyone. Can you hear me?
Yes, we can.
All right. Hi, good afternoon, everyone. I'm Nicholas Wong from Reddy & Co. Advocates. I'm a lawyer practicing in Sarawak. My counterparts in West Malaysia have already provided the law and information applicable to West Malaysia. For my part, I will be sharing some statutory provisions and information which are applicable to the employment of children in Sabah and Sarawak. Although Sabah and Sarawak have different labor ordinances, the relevant provisions in both states for today's topics are almost identical. In fact, the ordinances in East Malaysia, from what I heard from Aneera and Sara a moment ago, are in fact quite similar to Sarawak and Sabah. Okay. The Employment Act 1955 is only applicable in West Malaysia, as we know. Similarly, the Children and Young Persons Employment Act 1966, it's also only applicable in West Malaysia. So I will not be repeating all the West Malaysian Act, which are also applicable to East Malaysia. For East Malaysia, we have the Sarawak Labour Ordinance and Sabah Labour Ordinance respectively. Before we go into the Sarawak Labour Ordinance, I would like to draw your attention to another statute which is relevant to our topic, which is the Employees' Minimum Standards of Housing, Accommodation and Amenities Act. I will not go into this in detail as well, as it is applicable throughout Malaysia and not specifically to Sarawak, and I believe it has been covered earlier. Generally, this act makes it mandatory for employer to comply with the minimum standards of housing, accommodations and amenities for employment, such as to provide the employees with basic water and electricity supply at the workplace. In general, a person is deemed to be an employee under the Sarawak and Sabah Labour Ordinance if his monthly salary are not more than 2,500 ringgit. However, there are some exceptions to this under the schedule of the labour ordinances. I believe the threshold for this is different from West Malaysia. Currently, the minimum monthly wages in Sarawak are 1,200 ringgit and 1,100 ringgit respectively, depending on the areas. According to the Sarawak Minimum Wages Order 2020, the recent one, the minimum wages for the city council area is 1,200 ringgit per month, but the minimum wages for municipal area, which is further away from the city area, is 1,100 ringgit per month. Under the Sabah and Sarawak Labour Ordinance, there is a difference in definition of a child and a young person. Like Sarah has pointed out a moment ago, it is more or less the same. A child means a person under the age of 15 years old, and a young person means a person who has ceased to be a child but has not attained age of 18 years. So the question now is whether a child can be employed in an oil palm estate in Sarawak. I would like to draw your attention to section 73 sub 2 of the Sarawak Labour Ordinance, wherein it provides that the employment in which children and young persons may be engaged. According to this section, a child may only be engaged in the following four situations. A, the first one, employment involving light work suitable to his capacity in any undertaking carried on by his family. B, employment in any public entertainment in accordance with the terms and conditions of a license granted. C, employment requiring him to perform work approved or sponsored by the federal government or the government of any state and carried on in any school, training institution, or training vessel. And lastly, D, employment as apprentice under a written apprenticeship contract. Although there is no express prohibition for a child to work in an oil palm estate, subject to the types of work that a child is required to perform, my view is that Section 73 of the Sarawak Labour Ordinance does not allow a child to be employed for industrial purposes, including plantation, oil palm plantation. The position in Sabah is similar. However, the position of a young person is different. A young person is permitted under Section 73, sub 3 of the Sarawak Labour Ordinance to carry out various work such as employment in factory and employment in an industrial undertaking suitable to his capacity. Pursuant to Section 73, sub 5 of the Sarawak Labour Ordinance, no child or young person shall be or be required or permitted to be engaged in any employment contrary to basically two statutes: Factories and Machinery Acts and Electricity Ordinance of Sarawak, or any employment requiring the child to do underground work. So this is also similar to the provisions relating to women's protection. No underground work is allowed. So the only two statutes that is provided under Section 73 sub 5 of the Sarawak Labour Ordinance, as I mentioned, are the Factories and Machinery Act and Electricity Ordinance. Other than that, there is no express prohibition. For the employment that a child is permitted to undertake, he or she shall not be asked to work for more than 6 days in any period of 7 consecutive days. That is to say, a child cannot be asked to work for more than 6 days in a week. And this is provided under Section 74A of the Sarawak Labour Ordinance. Furthermore, Section 74B of the Sarawak Labour Ordinance states that no child shall be required or permitted to work in 4 scenarios: A, between 8 p.m. to 7 a.m., B, more than 3 consecutive hours more than 3 consecutive hours without a period of rest for at least 30 minutes, C, more than 6 hours per day, or if the child is attending school for a period which, together with the time he spends attending school, exceeds 7 hours, or D, to commence work on any day without having had a period of not less than 14 consecutive hours free of work. In fact, these provisions are quite similar with the provisions under the Employments Act 1955 of West Malaysia. Some people may ask this question: can a child or children enter into an employment contract which may run foul or at odds with the provision in the Contracts Act? The answer is yes, by virtue of Section 75B of the Sarawak Labour Ordinance. A child or young person shall be competent to enter into any contract of service under this ordinance. In fact, a child can even sue as a plaintiff for breach of the employment contract as against the employer. So the above are some pertinent provisions relating to employment of children in Sarawak, which is quite simple. We do not have a very comprehensive legislation like the West Malaysia 1966 Act, the Children and Young Person Employment Act. So at the moment, the Act has not been extended to Sabah and Sarawak. We do not have such comprehensive legislation apart from the Sarawak and Sabah Labour Ordinance, and also the prohibition under the Factories, Machinery, Electricity Ordinance, and the OSHA Act. Another important area to know before any employment can be made for non-Sarawakian is the immigration law concerning the East Malaysian state under the Immigration Act. Section 66 of the Immigration Act restricts citizens. Citizen here, I'm referring to Malaysian citizen. Section 66 restricts citizens' right of entry into East Malaysian state, which includes Sabah and Sarawak. A citizen shall not be entitled to enter an East Malaysian state without having first obtained a permit or pass, unless he or she falls within the exceptions. For example, he belongs to the East Malaysian state, or if he is a member of the federal government or state legislative assembly. The question of who can be considered as a person belonging to East Malaysian state is answered in Section 71 of the Immigration Act. It does not mean that a person must be born in Sarawak for him to be treated as a person belonging to the East Malaysian state. For example, someone who has a status of PR, permanent status of Sarawak, or a woman who is married to a PR of Sarawak can be treated as belonging to an East Malaysian state for this purpose. In brief, employees outside Sarawak will need to obtain entry permit and employment pass for Sarawak from the Sarawak state government for any employment within the state. Based on my knowledge, the only foreign workers that the Sarawak state government currently approve to work in oil palm industry are from Indonesia. I believe this is different from West Malaysia. And also from my understanding, almost all of the oil palm companies in Sarawak employ mostly Indonesian workers in their state, as opposed to Malaysian workers or other foreign workers. I was told that officially only Indonesian workers are allowed to work in the oil palm industry or the agriculture industry in Sarawak. However, there could be exceptions which are not within my knowledge, can be changed from time to time. I understand that some oil palm companies in Sarawak expressly state in the employment contract with the foreign workers that they are not permitted to bring any dependent into Sarawak. They cannot bring their wife, they cannot bring their children, failing which it will be a breach of the employment contract and they will not be allowed to continue with the employment. So this would mean that women and children are not found in large number in the oil palm estate in Sarawak. So this is applicable to oil palm companies in Sarawak where they employ large number of foreign workers. For today's speech, I am not covering areas which may be relevant to native customary rights. Those are mostly workers involving local farmers. Those are mostly the small estate holders. I will not be covering that in today's topic. So with that, I will conclude my speech for today. If there's any question, I am happy to answer. Thank you very much.
Thank you very much, Nicholas, Aneera, and Sarah, for a very, very insightful session. We're going to now start picking up some of the questions for Q&A. Audience members, if you do have any questions, please feel free to drop them in the Q&A box so we can pick them up as we go along. What I'm going to do is I'm actually just going to kickstart with a couple of questions of my own. And this is because obviously Sarah and Aneera and Nicholas, you've covered different aspects of the legislation for different jurisdictions. So I think when I ask these questions, I'm just going to make them quite general. And then, any of you, if you're inclined to answer, please jump in. I think my first question is around sort of enforcement. How effective is enforcement in this space where we're talking about child rights in, palm oil plantations? And is there a role that in-house counsel plays in managing such events?
I think I'll attempt to take that one. I think
Sarah?
that sadly, enforcement is lacking or lax. And most of the time, enforcement comes when there's a complaint or a whistleblower. So one example we can take into account is, the Employee Minimum Standards of Housing Act, which was briefly touched on by Nicholas earlier on. Before the changes to that act, it was called the Workers' Minimum Standard Housing Act. And the changes that spearheaded today is as a result of the kind of whistleblowing that came around these large corporations in the wake of COVID-19. The changes came so swiftly and so extensively because there's so much attention, so much media attention, so much international attention. And I think, it wouldn't be any different with the palm oil. A lot of these workers are invisible, and a lot of them are sidelined. So, that there are frequent immigration raids to ensure that immigration laws are complied with. But as far as employment laws are concerned, I think an investigation will only be kickstarted once there's a complaint or some kind of fire around that. Yeah.
Thanks very much, Sarah. Nicholas or Aneera, did you have anything you wanted to share in that space? If not, I will jump to the next question. Okay, I think I'll jump to the next question. This question specifically is for Nicholas. And the question is, are the Sabah and Sarawak labor ordinances undergoing the process of public consultation for the purposes of amendment? The person who submitted this question was, I believe, informed that this began in 2018-2019 and is wondering if there are any updates on that today. Would you be able to take that, please, Nicholas?
Yes, I'm not aware of the latest amendment since 2018 and 19. I will have to check on that.
Sure thing, no worries.
Yes, as far as I know, subsidiary legislations have been amended in 2008, and since then there is no major amendment to the Sarawak Labor Ordinance. If there's any specific areas in the Labor Ordinance which you want to ask, perhaps you can let me know. I'll see whether that provision is still applicable or it has been amended. Based on what I have, it has not been updated for a long time.
All right, thank you for that, Nicholas. I think we've got one more question. We talked a little bit earlier, I believe Aneera mentioned this, that there may be stricter regulations in the future. Is there any indication from anybody on the panel? Do we know what those things may look like, and if there's a timeline around that? Or is this, something that's on the ground and in progress, but we're not really sure at this stage?
Hi, I think I can take that.
Thanks, Aneera.
At the moment, no, it's a goal, and of course there's a lot of grassroots level stuff that is coming up, and it really helps when there's a public outcry about certain issues, especially to do with migrants and the various issues surrounding them. There are expected changes to the Employment Act. There are supposed to be more protective changes generally to labor laws as a whole. But in respect of child protection, I don't think that there's anything that is coming anytime soon, or maybe I can't remember if there is anything. There was recently the Sexual Offences Against the Children Act that came into force, and the Sexual Offenders Registry that came into force. Even that is that registry is not a complete one. Last I checked, I think there was only about a couple of thousand names. It's not in any way comprehensive, but certainly moves are being taken to protect issues surrounding child protection, such as child pornography, child trafficking. There are a lot of people on the ground that are working on it from in different ways and from different perspectives. In terms of new legislation coming up, I don't think that there's anything in the works at the moment.
Thanks very much for that, Aneera. We do have another question that's popped into the Q&A box. Thank you for asking this. The question is, are young persons allowed to work on rest days? I think this answer possibly may differ depending on whether you're looking at East or West Malaysia. Can anyone from the panel take that question by chance?
I'll take it from the West Malaysia perspective, because that's the only perspective I can take.
Thanks, Sarah.
A young person, no worker is supposed to be working on the rest day, including young persons. If you want them to be working on a rest day, you have to be paying them the pay that's commensurate with the rest day pay. Okay. Having said that, remember that under the Children and Young Persons Act, a child or a young person cannot work 7 consecutive days. Okay.
Great, thanks. Sarah, there's actually a follow-up to this. So the second part of this question, and you may have addressed this to some extent, if workers consent to work on rest days and they're paid the relevant wage rate, does that constitute a form of forced labor?
No, it does not. So work on rest days do occur. But you have to ensure that they are properly compensated for that and they're not forced to do it.
Great, thank you so much. Nicholas, would you be able to address
Yes.
this for me? Great,
The
thank you so
position
much.
the position of rest day is similar to West Malaysia as well. If any employee or child is required to work on a rest day, double wages will have to be paid. And it cannot be forced, it must be voluntary.
Great, thank you so much. I think we're going to wrap up our Q&A here. Thank you again to our speakers, Aneera, Sara, and Nicholas. It's been great having you on board. It's been great working with you